Hey, you can proceed.
All right. Yes. Good afternoon. My name is Adam Young. I'm a partner at Seyfarth Shaw here in Chicago. If you go to the next slide, please. The next slide. Yes, I'm here with my colleague, Matthew Sloan. We're here to talk about the new OSHA walkaround rule that's becoming effective this week on the 31st of May. If we go to the next slide, please. We're going to be a pretty quick hitter presentation here, the key facts that you need to know. What the existing law is, how it's changing on the 31st, the core challenge that's out there for it, how we recommend managing inspections with regard to that. I think one of the biggest failures we see from employers in dealing with OSHA is that they don't manage inspections properly. And it's absolutely critical to reduce the number of citations that you get. And this is just another area where inspection management really is crucial in dealing with labor relations and these potential third-party representatives. If you have any questions at any time, feel free to put them in the chat. We'll try to get them answered. Feel free to email Matt or myself, and we'll get back to you as soon as we can. If it's not your question, you're just asking for a friend, that's fine too. We'll make sure to get that question answered. We're going to try not to read from the slides for you today because that's boring, but no guide or discussion, and the slides will be available to you if there's any more information that you need. If you have any question on any safety and health topic, we likely have an article or a blog on it. We have a workplace safety environmental blog that you can subscribe to, where we give weekly updates on all the important things that are going on in this space for employers. If we go on to the next slide, please. Yeah, so I'll start with what are the existing rules for walkarounds. And currently, the general rule is that an employee representative can go on an OSHA walkaround. So OSHA shows up, they do an opening conference. Typically, they then say, well, we want to walk around and see the work site. So if they're there about an accident, they're going to want to go out and see that accident site. If they're there about a complaint, well, it's a complaint about the powered industrial trucks. They want to go out and see those powered industrial trucks. So that's called the walk around. And the general rule is that they can take employees with them on the walk around. The general rule is that the representative can be there during the physical inspection, and there can be additional representatives throughout the process. There is something that governs OSHA inspections called the minimum burden doctrine, and that says an OSHA inspection can only put a minimum burden on the employer. It can't disrupt the operations, and the same would be true with having representatives, but it couldn't be excessively disruptive. And I know some states have different rules. If we go to the next slide, please. With regard to third parties, the general rule now is that representatives shall be an employee of the employer unless it meets one of the exceptions. And that's where it's reasonably necessary to conduct an effective and thorough physical inspection. And OSHA gives specific examples, an industrial hygienist or a safety engineer, right? These are safety professionals that could aid a safety inspection. We have seen third-party non-employee representatives at unionized work sites for OSHA inspections in the past. And typically it's very highly sophisticated equipment and machinery. And the operators who are members of that union who operate the equipment might not have the expertise on process safety management and chemical safety. And sometimes unions have sent a third-party representative to accompany an OSHA inspection. I haven't found that they did much on that inspection. They didn't talk much, or we never heard from them again after the walkarounds, but that's been the very limited context where the existing rules have applied in the past, where you have this on-site third-party union representative who doesn't actually work at the facility. In terms of disputes, if there ever are disputes as to who's the representative, the existing rule says that OSHA's compliance officer can resolve those disputes, and they can consult with a reasonable number of employees to do so. And that kind of gives the background for the new rules. If we're going to go to the next slide, please. Matt, you want to talk about additional rights?
Sure. So after a fatality or catastrophic event, we have seen several situations where a union, if this is a unionized setting, will want to conduct their own independent safety investigation. The NLRB will engage in a balancing test. And what the case law essentially states is that the independent safety investigation has to be conducted at a sort of mutually agreeable time and with the least amount of interference to the operations of the facility as possible. And so employers can't just tell unions in a unionized work environment that they cannot conduct their own independent safety investigation. But again, that has to be at a mutually agreeable time and must be conducted with the least amount of interference with the site's operations. You all may have heard of wine garden rights, especially if you do have unionized plants or shops. The rule for when an employee can have a union representative with them during an interview is that if the reasonable employee would anticipate that discipline might result from the interview, they are entitled to a union representative during that interview. We think with this current NLRB, they are very likely to take the position that an interview conducted with an employee after a fatality or other catastrophic event would entitle that employee to union representation during the interview because of the prospect of discipline. We have seen situations where a union has submitted an RFI, a request for information, to the employer, asking for privileged documentation, attorney-client privilege documentation, or attorney work product. Those are not complete defenses, as strange as it may sound, but the NLRB will engage in a balancing test, and historically, they have given great weight to the attorney-client privilege, and so they have said more often than not that that outweighs any need by a union for that information. And then one point that we did want to emphasize is with currently unionized work environments, consult the CBA. Make sure that you are taking steps that align with what was previously agreed to in the CBA. That should be your starting point if you're dealing with a unionized setting. So, Adam, back to you.
Oh, sure. If we go on to the next slide, please. So the new rule that takes effect on the 31st, but what's the big change here is that the general rule is not that the employee representative is an employee of the facility. The representative can either be an employee or the employee of a third party. So it broadens the grounds that folks could be out there as employee representatives. It eliminates the reference to industrial hygienist or a safety engineer, and makes it much broader. It's about skills, experience, the hazards, conditions of the workplace, or even just language or communication skills. So while the person still needs to be reasonably necessary to be there, the compliance officer has really wide discretion to allow that person on site and determine they're reasonably necessary. And it's not about safety and health even. It's much broader with regard to the options that they can use. And we anticipate, generally speaking, that OSHA is going to be very deferential to the union. We're seeing that not just in the context of third-party representatives, but during OSHA inspections, right? I've attended OSHA inspections where OSHA has gone to the inspection, done an opening, and then just met with the union rep for an hour, and then only wanted to interview people or see things that the union rep told them about. So we are seeing in the Biden administration a lot more deference to labor unions in the conduct of the inspections. Any thoughts on that before we go to the core challenge, Matt?
No, I think we're ready to move on to the core challenge down in Texas.
Sure. Next slide, please. Go ahead, Matt.
Sure. So there is presently a challenge to the new walk-around rule. Some of you may recall during the Obama administration, that administration attempted to implement this same sort of rule, but through informal guidance instead of the notice and comment rulemaking process. Here, OSHA has engaged in the notice and comment rulemaking process, and so this challenge is on different grounds, but we're paying close attention. A similar challenge was brought to the informal guidance that I just referred to in a different federal district court in Texas. We have not seen any sort of injunction yet, but it is possible before the rule goes into effect in just a few days that we do receive some update from the presiding judge here, potentially enjoining the rule. But for now, we recommend that all employers, whether unionized or not, prepare as if this rule will go into effect.
Sure. Yeah. I mean, if we want to go on to the next slide, I think the Chamber of Commerce likely chose the Western District of Texas because they think they're most likely to get a preliminary injunction out of them. I guess we can't comment too much as to the likelihood of that, but they've raised several grounds to potentially throw out the rule. The Administrative Procedures Act, Fifth Amendment, among others. So switching gears to kind of what are our recommendations on dealing with this issue as it comes up, starting 2 days from now. One is obviously to have a written plan in place. What are we going to do? We have a playbook. We have recommendations on different options you can do. And it kind of takes you play by play, and we're happy to provide that if anyone who's interested in it. OSHA shows up on site, right? They're going to do an opening conference with you initially. We highly recommend that you have a point person who deals with OSHA. They're notified. You can make OSHA wait up to an hour according to their field operations manual before you begin that opening conference. And then that allows you to get the point person there. And during that opening conference, we want to learn the basis for their inspection. If we're made aware at that opening conference of any third-party representative who's on site that's going to be part of a walk-around, we want to figure out all the details as to who that person is, who are they employed by, are they qualified, and what's the basis to understand that they were selected by employees at the site. So those are facts we're really going to want to dig in on to see, which of the responses we're going to want to take based on the information in front of us. In terms of legal defenses, maybe this will get the discussion started, Matt. We got a question. Can OSHA invite a union representative on an inspection in a non-union facility? So can OSHA invite them? We go to the next slide. Maybe you want to start with that.
So the outside third-party representative needs to be selected by employees at the site. And so I don't think it's the case that OSHA can themselves autonomously request that an outside third-party representative be present. Now, OSHA does have its ranks of industrial hygienists who often become involved in inspections if the inspection requires it, but they cannot go out themselves and bring in a union representative or any outside third-party representative. That outside third-party representative needs to be selected by employees at the site. I emphasize that over and over and over. And if there is a question as to whether the outside representative has been selected by employees at the site, we would recommend engaging with the outside third-party representative, him or herself, or the OSHA compliance officer to vet whether that person has been selected by employees at the site. Because if you start asking employees at the site whether they selected this person and other questions related to the decision to select this person, then you start to potentially run afoul of the National Labor Relations Act, which prohibits interrogation into protected concerted activity. This current National Labor Relations Board is getting very close to asserting that any safety-related activity is inherently concerted. And so you have to be very careful when talking to your typical hourly employee about their request for the presence of a third-party representative, but that does not limit your ability to get information about this person when they arrive, and getting additional information from the compliance officer to the extent that they have additional information about who this person is, where they came from, and why they are necessary to the effective to an effective inspection. Sorry, that was my long-winded response there.
Yeah, sure. Other concerns that we may have, trade secrets and confidential information is a huge concern we're getting from a lot of our clients. The concept of trade secrets and confidential information is extremely broad in OSHA inspections. And that's because of FOIA and how FOIA defines commercial information and how the Supreme Court has defined it. And that's, anything that's non-public that you created for commercial purposes is protected by FOIA. So if it's stamped confidential when you turn it over to OSHA during your inspection, that means that they're not allowed to turn it over if they get a FOIA request. So we know the OSHA end, those documents are protected. But what about this third-party representative? Can they take photographs? And if so, can we stop them from disclosing them publicly? Well, what are your thoughts on that, Matt?
Yeah, it actually poses a really interesting question. I think this current National Labor Relations Board, or really any National Labor Relations Board in the past, would say that an employee taking photographs of an allegedly unsafe working condition and submitting that photograph to OSHA would be protected concerted activity because there is a dangerous working condition. They're reporting it to the to OSHA, and they're taking that step on behalf of themselves and other employees. That doesn't mean that any employees have carte blanche to take pictures of our equipment in the vein of what Adam just discussed. But we're also envisioning a scenario where during a walk-around inspection, under these new work rules, employees that have designated a third-party representative, and if the employer grants that third-party representative access to the site, that the employees during the physical walk-around might direct the third-party representative to take photographs of equipment of allegedly unsafe conditions during the physical walk-around. And is that protected concerted activity? Under this current National Labor Relations Board, probably. But a lot remains to be seen. There are clearly some gray areas in these rules, revised rules, and the intersection between the rules and what the National Labor Relations Act protects and doesn't protect is something that I'm curious to see play out over the next few months, assuming that the rule isn't enjoined by the Western District of Texas.
So, visitor agreements, assumption of risk is an option here too. If you're bringing this third-party representative on site, you're going to let them join a walk-around. You have the opportunity to have them follow all your normal rules, right? And a lot of our clients have a site-specific safety instruction that has to go on with everyone who walks onto that construction site, for instance. And that may take 5 minutes. You can make the person do that. If you have an assumption of risk or visitor agreement that your visitors normally sign, OSHA's FAQ says you can have the person sign that too. Adam, what are your thoughts on that issue, if any, Matt?
In fact,
to having union folks sign those.
Yeah, in fact, in the Department of Labor's Q&A that was published alongside the revised rule, they appreciate and acknowledge that employers have guests at their work sites sign confidentiality agreements requiring those individuals to follow the site's rules, take other precautions, especially with respect to safety. They've said that those sorts of agreements are fine when dealing with one of these third-party representatives, so long as you have all guests sign that same confidentiality agreement when they visit the site. But if you are only requiring third-party representatives pursuant to these walk-around rules to sign the confidentiality agreement, but not anyone else, then you do run the risk of running afoul of the National Labor Relations Act. And so the moral of the story is make sure you are treating all of your guests the same and not singling out any of these third-party representatives in any way.
One of the questions we got is, does this apply in all states? Federal OSHA enforces the rules as to private employers in 27 states, and then 23 states, California, Oregon, Washington State, many big states have their own OSHA state plans. So initially, this rule is going to become effective in federal states with regard to private employers. That being said, there's rules that say that the state plans have to be at least as effective in protecting employees. If new rules are passed, they have to address that and be equally effective within 6 months. And then finally, a lot of state plans for, aside from some substantial standards they create on their own, they just adopt the federal regulations and go with them. So while initially this is going to be an issue we anticipate in the 27 federal states, everything plays out in the ensuing months when it comes to OSHA inspections. So, Matt, we got the question, can the employer challenge the OSHA inspector regarding the need for the third party to be involved? What are your thoughts on that?
Yes. If there is reason to question whether the individual has been selected by employees at the site, or if there is reason to doubt that this person has credentials that make them qualified to serve as a third-party representative, you are absolutely entitled to challenge, able to challenge the appropriateness of that person's presence during the inspection. And OSHA and the Department of Labor have anticipated that this might happen, that employers will likely have questions about whether certain representatives are really qualified to serve in that role. And what OSHA has said in the guidance that was issued alongside the revised rule is, in that event, the compliance officer has the discretion to continue the other aspects of the inspection, like employee interviews. The compliance officer can end the inspection and go back to their area office and consult with the leadership of that office and potentially solicitors with the Department of Labor, or right there and then the OSHA compliance officer can call their site leadership and decide next steps. In the most extreme of circumstances, let's say OSHA does take the position that this person is qualified, they could seek a warrant if an employer refuses to have that third-party representative participate in the walk-around inspection, and OSHA believes that that person is qualified to serve in that role. They could come back with a warrant requiring that person to participate during the inspection. And there's a whole legal process attached to the refusal of refusing to grant access to an OSHA representative with a warrant.
Yeah, that's not clear. I haven't seen a warrant based around the third-party representative, and I think they can be obtained ex parte, meaning we wouldn't be in there with them, but likely a warrant is only going to provide OSHA the rights to what it can do anyway. It's going to say OSHA can come in and do its inspection. It'd be interesting to see how it plays out with regard to a warrant and third parties and what a judge would actually grant. But yes, they can seek a warrant. They can come back with the marshals. At that point, we have to abide by the law and abide by what the warrant says for sure. One point to make here is this is just a walk-around rule, and right, that's just part of an OSHA inspection. We talked about the opening conference. We have walk-arounds. We have employee interviews. We have management interviews. We have document requests. We have a close-end conference. None of those other things are these people allowed to attend, right? This rule doesn't allow them to sit in on employee interviews, doesn't allow them to be party to communications, to review documentation. We think this rule is probably going to be most at issue at locations that are non-union locations where there is an on-site organizing campaign. That being said, as the Chamber of Commerce pointed out, in its lawsuit, there's a lot of other potential here. I have a lot of clients that are concerned with industrial espionage, particularly in very high-tech industries in California, among other places, that they think third parties are going to try to use, any way possible to try to get on site. So there's some concerns there, and I think there's a lot of overlapping strategies to deal with trade secrets and confidential information. And then plaintiffs' attorneys is something that's been raised by the chamber as well, that plaintiffs' attorneys may try to get someone in to figure out and influence the OSHA inspection during the walk around by pointing out stuff that they think should be cited in ways that can either drive later comp benefits or drive some sort of tort lawsuit. So that's an option there. Do you want to talk about disruptions at the inspection, the final bit here? No?
Well, I wanted to know one important point to bounce off of something that you just said. The limitation to the physical walk around is an important note, right? This doesn't grant anyone access to the other aspects of the typical OSHA inspection. But currently, there are some state plan states that do grant outside third-party representatives in unionized settings the ability to participate in not just the physical walkaround as a matter of law, but also the opening conference. One that I'm thinking of in particular is the state of California. And there, the California Labor Code says that an authorized employee representative must be provided an opportunity to accompany the compliance officer during the course of the inspection, including the walkaround, and that person should be invited to participate in the opening conference. So there's definitely a more sort of intimate connection to organized labor in the state of California, as it currently stands.
We talked about minimum burden before, and I mentioned disruption. That would be another reason where you would be able to keep these people out. Or if there is a third party, you allow them to go down the walk around. They don't stay within the confines of the ground rules that you lay out in the opening conference or the pre-walk meeting. That would be a reason to keep them out. What is disruptive activity? Wandering off, not staying with management. That's a huge one. Matt and I together have seen compliance officers do that at inspections. We've kicked them out and we never heard from them again. That same would be true for the third party representative. Taking unauthorized photographs or videos, particularly of this, sensitive trade secret information, that'd be a reason that you could cancel the walk around as well and escort the person out. Solicitation, the frequently asked questions from OSHA, say handing out union authorization cards, trying to interview people, soliciting them. That could be another form of disruption to keep folks out as well.
Yeah, and the OSHA compliance officer is supposed to be the employer's ally in that situation where the outside third-party representative is not respecting the bounds and limits of the inspection, wandering off, attempting to solicit employees. The compliance officer is supposed to take reasonable steps to curb that activity. But if things are not improving, if the third-party representative is not abiding by the rules, even after the compliance officer tells him or her to quit it, call a timeout and get everyone off the floor and figure it out. If things go sideways, southways, get folks off the shop floor, into a room, away from equipment, and definitely raise your concerns about the individual's conduct with the compliance officer. And compliance officer is supposed to respect those concerns, especially if their efforts, the compliance officer's efforts, didn't resolve the situation.
So we got a question from Jay. Can I record the OSHA inspection? And I guess a couple things. In a lot of states, it's a crime to surreptitiously eavesdrop or audio record someone without their consent. So I wouldn't want anyone to get into hot water there. He has to need their approval. So yes, to legally record someone in some states, you need their approval to do so. Would we recommend that anyone audio or video record an OSHA inspection? Almost never. Would I recommend that? I think taking pictures to show where an OSHA compliance officer goes during an inspection is valuable. Having an audio or video recording of the whole thing generally is not. And it may be something that, may be used against you in the future if you choose to do that as well. If it's not privileged, the audio or video recording that you make. So that's our, should we go to the next slide?
Yes, the CLE code. This is my responsibility here. The CLE code is SS, as in Seyfarth Shaw, 3135. And in fact, you can use the QR code on your screen, and that will bring you to the form on which you'll note that code, again, SS 3135. I think there's also a link to that form in the email that you all received with the link to this video this morning.
Ben, you want to go to the next slide and finish it out for us?
Yeah, so we talked about what happens if we prevent a third-party representative from participating. The compliance officer can terminate the inspection or move on to different areas of, well, different parts of the inspection, like the employee interviews. And then the compliance officer is supposed to report the refusal to their supervisor, who is the area director, who will discuss it with OSHA's attorneys at the Department of Labor Solicitor's Office.
Next slide. So, we recommend having a plan. We talked about a playbook that we put together. We think, it has to be tailored for who's going to be using it and what options and what preferences you all have. We're happy to provide that. Question was asked, can we search OSHA and or a third party to make sure they're not wired to record the walkaround? I wouldn't recommend trying to strip search an OSHA compliance officer. I don't think that's going to win over any popularity. I think they're going to come back with a warrant, and they're going to come back with a lot of people and be really pissed off. So probably not the best idea. As I said, it's illegal in a lot of states, in two-party consent states like here in Illinois, for people to report you. So probably not a huge risk that people are wearing a wire to come into your work site. We got a request to repeat the CLI code again.
Sure. SS3135.
Thank you all for coming. Any closing thoughts, Matt?
No, thank you all for your time. We hope this was useful. And if you have any follow-up questions, we're always around.
Thanks.
Okay. Take care, everyone.